I would like to thank the organizers of this very interesting activity, the President of the Supreme Court, Vesna Medenica of Montenegro, and also Mark Donfried, the General Director of the Institute for Culture and Diplomacy. Of course, for me too, it's a great pleasure and honor to be here, to be part of this conference between colleagues, to discuss for such very important issues related to the interaction, let's say, between international law in general and domestic law, especially in the field of human rights. And in this framework, the obligations we have as members of the Council of Europe, as members part of the European Convention of Human Rights, to respect the jurisprudence of the Strasbourg Court. I will try to have a short overview of the problem, of course, because the subject is huge. It's a very big one. And I have prepared also some sliders. You can see also my contribution, also main problems treated in my contribution to the sliders we have in the front. So, it is quite clear that the relationship between international law and domestic law, it's a great importance to it. It's a fact. Not only theoretical importance, but also practical values in everyday life. Because only through judgments, only through the contribution given from the judiciary, it is possible to realize in everyday life, in practice, human rights declared in every democratic state, in every democratic constitution. The increase of the role and the weight of the international law in the framework of the integration and global processes. Sometimes, due to these processes, we are going sometimes at the heart of the notion of sovereignty. I have mentioned shortly here two very interesting reasoning of two very important constitutional courts, the Czech Constitutional Court and the German Constitutional Court, about that problem. First, the judgments in the framework of the, let's say, conflict before the ratification of the Lisbon Treaty. The Czech Constitutional Court stressed that the notion of sovereignty has dramatically changed its meaning. It's not understood as an absolute sovereignty. It is much more a practical question. And a year later, the German Constitutional Court stated that states with the free will of the sovereign are obliged to give up important portions of sovereignty to the international organizations and mechanisms, but in a controlled form and case by case. The last word belongs to the sovereign. This cooperation, of course, is very important, especially in the field of human rights. The cooperation can be divided in two huge fields, let's say, in the European continent. First, of course, in the framework of the obligations we have being members of the United Nations. And we know all that one of the main reasons that the United Nations was created was to secure peace and security in global world, but also contributing in that sense for protection of human rights and fundamental freedoms. And in this framework, of course, there are some organs, universal political organs of the United Nations who takes care about human rights, but also including here the United Nations High Commissioner for Human Rights and the Committee of Human Rights changed in 2006 to the Council of Human Rights with a center in Geneva. And secondly, we have also in the framework of the European or the United Nations the supervisory mechanism to supervise the obligations of the states being part of the Convention of Human Rights in the framework of the United Nations. And secondly, in regional level, and without doubt that European system is the most effective and successful one, especially if we have in mind the Council of Europe, European Convention of Human Rights, and European Union, especially after the Lisbon Treaty, because we all know that according to the Lisbon Treaty, the Charter of Human Rights, it's now part of the treaties of the European Union. So, having in mind that problems, of course, we have to stress again that the role of the national courts implementing international law and standards today, it's of a very, very important. And in that regard, I have to mention here that the Declaration of International Law Institute in Milano in 1993, that national legislation should give the national courts the right to interpret and implement international law in full independence, especially international law of human rights. In this framework, of course, the creation of the Council of Europe in 1949 with the main objectives for strengthening democracy, rule of law, and protection of human rights was a very successful event. Then the European Convention of Human Rights, approved some months later on, of course, had at the time two main objectives. First, the necessity to guarantee international peace and security and to react against totalitarian ideologies, communism, fascism, and National Socialism, but also to respond to the need to have a European Bill of Rights which should have a real impact to the national legal order of member states. And today we are testimonying that this is really a very good development nowadays. The convention is enriched with 16 protocols with the aim to make it as much as effective. Especially, we have to mention here protocol number 1, protocol number 6, 11, 14, and 15, and 16, two late protocols which make, especially the last protocol, make the dialogue between national courts and the European Court of Human Rights very effective one, because, as you know, now the European Court of Human Rights has the possibility to give also advisory opinions with a request of the High Court, of the Supreme Court, of the state members. So, in that manner, the European Court of Human Rights and European Convention of Human Rights, let's say, are victims of their success because the burden, the backlog in the last years of the European Court of Human Rights has been huge, because you know that the European Court of Human Rights covers a jurisdiction with approximately 900,000 million inhabitants. It's really a big problem, but also it's a huge development for all member states, 47 states of the European Convention of Human Rights. And if we see the jurisprudence of the European Court of Human Rights in the years, we can stress just at the beginning that the contribution of the European Court of Human Rights jurisprudence is of many, let's say, dimensions. First, they have contributed to guarantee human rights, rule of law, and principles of liberal democracy. Secondly, they have contributed, the court has contributed to guarantee an open democratic society, especially if we have in mind Article 9, freedom of religion, Article 10, freedom of speech and access to information, freedom of assembly, Article 13, Protocol 1, Article 3, this is the freedom of election, and so on. And main for these articles, Kokinakis or Linges or Vogt and Mohin. For example, if we have in mind, for example, the Belgian linguistic case, in that case the government says that c'est là le domaine réservé pour le cour national, pour la Cour de Belgique. But the court answered that time that, okay, but you should have in mind that there are some standards which need to be observed by contracting states in their relations with the persons under their jurisdictions. And these are also the minimum standards seeking to be as minimum standards in the framework of the European Convention of Human Rights. And what is very important too, third, through the jurisprudence of the European Court of Human Rights, it's made possible also to control the legislation, especially through pilot decisions. In that regard, especially important, it's for the new democracies, because after 90s, in constitution or amendments, in the new constitution or amendments approved in the new democracies after these changings, are now foreseen clearly the judicial review of the legislation, having in mind the standards of the European Court of Human Rights. Also in Great Britain, a country with a very consolidated democracy, according to Human Rights Act of 98, House of Lords, now the Supreme Court, can review the legislation, having in mind the jurisprudence of the European Court of Human Rights, but cannot annul it. Also, in Germany, which has a very developed constitutional control, it's possible to control the legislation on the basis of convention, although in some cases, in the case Gergely or Carolina of Monaco, there have been a lot of discussions on that regard, because we have, if you remember, a decision of the German Constitutional Court which divided the obligations which Germany, as subject of international law, has toward Strasbourg, let's say, and also the obligations that the constitutional organs within the country have toward the constitution. Fourth, it is possible also now to have judicial control on administrative decisions, initially not covered from Article 6.1 in the notion of civil rights and obligations. But now it is covered, and if it's the case for the exceptions, we have the case Eskelinen against Finland. Now the exception should be concrete and should be foreseen from the law. Fifth, the courts at the national level are also obliged, and the constitution to have a controlled limitations or controlled restrictions of fundamental rights and freedoms, having this by law, by public interest, or protection of rights of the others, and also implementing the principle of the very well-known constitutional law principle of proportionality. In the new democracies, of course, it's a big progress, although in some countries there remain some problems, including Albania too. That's the reason why do exist also the necessity to profit from the experiences of developed democracies like Germany, France, Netherlands, or Scandinavian states. But I repeat again that the role of the judiciary, especially the role of the Supreme Court and constitutional courts, is of a very important implementing the standards of the European Court of Human Rights. As I mentioned, there are achievements in the new democracies, but remains also problems, because our new democracies, in the implementations, especially for Article 2, guaranteeing the right to life, Article 3, prohibition of torture, Article 5, security of persons, Article 6, due process of law, Article 1, Protocol 1. There are a lot of problems in new democracies, including Albania too, etc. But, of course, it needs to have I am coming because I will repeat the case Herman and Hurst later on, to respect the principle of subsidiarity and the principle of margin of appreciation and dialogue between the courts, now fixed in the protocol, not 16, in the protocol number 15. The Albanian case. And the Albanian case, in general, the place and the role of the international law is very important. I say also often with my students that also international law in general have a very privileged place. If we have in mind Article 5, 116, 122, 123, and especially for human rights, Article 17, paragraph number 2. In the Article 5, it's written that the Republic of Albania applies international law binding upon it. Of course, it's not only a general declaration. This is more than that, because with international law binding upon it are not only treaties, but also the so-called jus cogens and obligations erga omnes. The majority of these obligations belong, of course, to the field of human rights. In Article 116, its normative acts are effective in the territory of the Republic of Albania, in first its constitution, and then ratified international agreements, and then the law, because ratified international agreements are over the laws. And Article 123, which gives the possibility to the Albanian state to give powers specific issues, on specific issues to the international organizations. It's quite clear that the international law has a special place, supralegal but under constitutional status. In the Article 122, it's written quite clear that in case of conflict between the laws, internal laws, and international law, international treaties, ratified and published in Albania, prevails the international treaties ratified from the Albanian side. What is quite a new experience in the Albanian reality is Article 17 of the Constitution, in which it's spoken about the possible limitation of human rights. It is said that limitation of rights and freedoms provided by the Constitution may be established only by the law, in the public interest for the protection of rights of the others and in proportion to the situation. But in paragraph 2, these limitations may not infringe the essence of the right and in no case may exceed the limitations provided for in the European Convention of Human Rights. This means that the European Convention of Human Rights has a special status within Albanian legal system, if not over, let's say at the same level with the Constitution, as regard the limitation. This is not a formal position, but a real substantive one. And practically, of course, it helps the judges to refer to the judges of all levels, to refer quite often to the jurisprudence of the European Court of Human Rights, including also judges, of course, of the Supreme Court and of the Constitutional Court. That's the reason why in many decisions, especially in unified decisions of the Supreme Court, and in many decisions, especially at the individual claims in Albania, in the constitutional courts, you find a lot of references to the jurisprudence of the European Court of Human Rights. I don't want to take a lot of time, but I will shortly say that till now we have about 50 judgments and 320 decisions against Albania. About 400 applications are pending in the Strasbourg Court, especially the pending cases are for Article 1, Protocol 1. Main problems we are facing, of course, achievements are quite clear and progress is quite clear, but we have problems especially with Article 2 sometimes, inhuman treatment, because conditions in prisons and in the police detentions are sometimes problematic. That's the reason why, quite right, the European Court of Human Rights has found violation of Article 2, inhuman treatment. We have problems, Article 3 of the European Convention of Human Rights. Article 6, we have problems with Article 6 in many directions. The judgment in abstentia, it's a very big problem because in our codes of procedure we have taken a lot from the Italian system, both codes of procedure, criminal procedure and civil procedure, but also they have a lot of problems. And after the Cetinje case, they changed their codes, but we haven't changed the codes. It's needed to change very quickly the standards in Albania because are given the decision Xhezair, Scala, and other decisions for violating this standard. We have problems with the judgment within reasonable time. Also through the model taken from Italy, also the codes of procedure, because sometimes a normal case lasts 10, 12, 13 years. It's a huge problem in Albania. And also you should have in mind that actually in the Supreme Court the backlog is around 10,000 cases. We are trying to make some changes in the law, but it's really a problem. And we have also problems regarding the execution of final decisions of the court, which is also linked with the standards of the Article 6. Generally speaking, of course, as a new democracy, we have problems in general in judiciary, raised also in progress reports of the European Union. These are problems not only for Albania, but for all of the region. We have the candidate status. We intend to be part of the European Union, but also we have to strengthen judiciary. We have to contribute much more to strengthen the rule of law, to fight against organized crime and against corruption, and so on. But the main problems we have in Strasbourg are the problems linked with Article 1, Protocol 1, as I mentioned before. There are problems with the article which requires for the member states to respect property right. In many decisions against Albania too, but also in pilot decisions given, let's say, in Broniowski case, for example, against Poland, or in Anastasiou against Romania and so on, but also are given two semi-pilot decisions against Albania, Drisa and Ramali, one press declaration and one pilot decision a year ago, Manushache Puto against Albania, in which the Strasbourg court has stressed quite clearly that Albania needs to change the law, especially the law on the restitution and compensation of the land taken during the communist regime. It's a huge problem in Albania. And also has said that to take also financial and administrative and organizative steps to respect the standards of the European Convention of Human Rights. We had to fulfill these requirements at the end of June this year, but we the government asked to postpone the deadline, and it postponed for the next year. And the government now is trying to fulfill these obligations, but you should have in mind that only because the Albanian state is obliged to respect final court decisions for the compensation and restitution of the property taken in the communist regime, it remains for the government to pay milliards of euro to the individuals. Now only some concluding remarks. Of course, European Court of Human Rights and the jurisprudence of the European Court of Human Rights have played a very important role in strengthening democracy, rule of law, and the protection of human rights in the new democracies. However, it remains a lot to be done for really effective protection of human rights. The role and place of judiciary in that process is of very important. National courts and European Court of Human Rights has to fight side by side for human rights, considering themselves as natural allies. As I mentioned, this dialogue will be strengthened, especially through the protocol number 16. As a general rule, national courts have the obligation to meet the requirements of the European Convention of Human Rights. At the other side, European Court of Human Rights has the obligation to respect the principle of subsidiarity and the principle of margin of appreciation, mentioned now quite clearly also at the preamble of the European Convention of Human Rights, according to protocol number 15. National legal systems should foresee the potential possibility to review judicial decisions, civil, administrative, and criminal, if the European Court of Human Rights stated a violation of European Convention of Human Rights, and if that decision is based on this violation. Thank you very much. Faleminderit and hvala lepa.